Okay, ठीक, all right, we can join. I am ready. I'm just joining you. Section 11, 12 खत्म किए हम लोगों ने. Just drink some water. Yes. What is the relevant section we were using? Discussing rather. काफी फास्ट आ रहे हैं ना हम लोग. This Friday I may not be there. Just see that in case even Bombay.
Sir, we have to do from section 14 of Evidence Act.
14. Okay, 14 is a lengthy subject. 14 is a very important section which helps because circumstantial evidence is not defined under the Act. What is mens rea is not defined under the Act. Section 14 padenge with illustration. You come to know what is the meaning of circumstantial evidence. You come to know what is the expression, the motive behind crime. Animus, what is the animus of the person? What is the intention of the person? तो ये सब चीजें, the state of mind आदमी के, उसके दिल में क्या था, दिमाग में क्या था, concealed fact, all secret crimes which are committed or secret transactions which are committed in civil transaction, you will come to know. This section will pinpoint you how as a cross-examiner, you will be entitled to. This is the strongest weapon of the cross-examiner, section 14. Of course, the entire Evidence Act, you should know that each and every section provides you the remedy, but section 14 is, according to me, very, very crucial and important for a cross-examiner in eliciting the circumstantial evidence. Both the prosecution as well as the defense can use these against each other's witnesses. In civil cases for proving damages, you're proving breach of trust, various things. Let us see, that's a very interesting subject. Open this up. Yes, I will get ready. Mental, physical conditions of a witnesses of the prosecution. Okay. Yes. Yes. आ जाइए आप. How these facts become relevant? Whether you are not pleaded, you need not plead because the Order 6, Rule 1 and 2 CPC tells you have to give only material facts and not the evidence. So don't be confused that and you are not pleaded it, you cannot lead the evidence. Evidence ke liye there is no pleading required. If the only relevancy and the admissibility is very important. How it is based on fact issue and connectivity and relevancy under the evidence. Now start. Facts showing existence of state of mind. What was the state of mind of the accused person at the time when he committed the offense? Sudden and grave provocation. उसका mind खराब था क्या? दिमाग खराब था क्या? Was he drunk? Was he intoxicated? Did he react to some strong situation? ऐसी हालात में what was passing through his mind? तो illustration आपको उसमें दिए गए हैं section 84 onwards IPC के अंदर. When a person can take the plea, which is not, though you have committed the crime, but the crime committed in intoxicated frame of mind, sudden and grave provocation, ये सब चीजें, these are all results of a psychological imbalances of man. Yeah, facts showing the existence of state of mind, number one, or a body. तो तुम्हारी हालत कैसी थी? Whether a person who is bedridden, was he capable of committing any crime? was he a person who is physically infirm of advanced age? Allegation made against him. इसने कुल्हाड़ी उठा के मार दिया उसको भाग के 6 किलोमीटर. You can lead evidence. His body condition did not permit him. He was confined to a cot. He is a senior citizen. The allegations, you can lead evidence with regard to his body. You can, if he cannot himself come to the court of law, you make an application for appointment of a commissioner to come and see, and you examine the expert doctors के लिए, and whichever person he is under treatment, or witnesses who have seen his condition to examine, or bodily feeling, unke bodily feeling, what was in his mind. So offenses like fornication, no? That is a fornication, that is what you call it, the offense which has now been decriminalized by the Supreme Court in the IPC. What is the offense? The offense of what it is? I'm forgetting it. The what is the offense you're committing against another woman when you're a married man? Huh? भूल गए? मैं तो मुझे adultery is no one offense, but if you're a married man or a married woman having a relationship with another woman is an offense, isn't it? Under the Indian Penal Code, matrimonial offense है ना 497 498 खोलिए जरा. Bigamy is an offense, isn't it? Bigamy is not abolished. 490, yes. जरा आईपीसी पे ध्यान दे लेंगे हम लोग. Counterfeit coin 498 possession 489. Adultery has been abolished 497. The Supreme Court abolishes it. वो अलग बात है. Adultery तो गया. Then next offense is enticing or taking a woman detained with criminal intent of a married woman. 498 to है इसके अंदर. So that is those of you who wanted to know the judgment of the Supreme Court, where 490A has been declared cannot be prosecuted. Joseph Shine versus Union of India, EIR 2018, Supreme Court, page number 4898. Okay, that is not an offense, but a woman can take a divorce. Man can apply for divorce in a family court. You can go and say that my wife or husband, my spouse is living in adultery. It is causing me grave mental torture and agony. It is not possible to stay. Adultery is not abolished in matrimonial litigation. And adultery can be a cause for claiming damages also. Please note that under the law of tort, you can claim damages. Yeah, both of them can claim, both the spouses, if adultery is established. So only as a crime under the Indian Penal Code, section 497, which had prescribed a punishment initially, which was a 5 years punishment for the adultery के लिए. So the earlier judgment in Somitra Vishnu versus Union of India has been overruled by the Supreme Court in Joseph Shine, the Constitution Bench judgment. 498 तो है, 498A भी है अभी तक, cruelty to women. Yeah. Then bigamy is very much there. Please say bigamy is an offense, that is 493. Offenses relating to marriage, cohabitation of a man, deceitfully inducing a belief of lawful marriage. 493 abhi bhi offense hai. You can prove this particular offense. You introducing section 14, and marrying against during lifetime 494 abhi bhi zinda hai. This is an offense that you cannot say that here can be read as a adultery. Then concealment of a marriage is an offense, section 495. Then marrying ceremony fraudulently gone through without lawful marriage, 496, ये offense. If 497 को struck down किया गया, other things in chapter 20 of the Indian Penal Code, 493, 494, 495, 496, 498, 498 are still available for the spouses. Please note that. So this will be useful, this section 14, for proving this kind of offenses. Yes. Facts showing the existence of any state of mind. Any state of mind. What was at the time of the commission of the offense or before the commission of the offense? Like under section 8 में see के आपने when a person has been administered a poison, पहले administer करने से पहले उसकी क्या हालत थी? What was his bodily condition? And after administering the poison, what was the condition? So evidence can be led both the ways. Similarly, here also for proving the crime, for proving the feeling of a person, you can lead evidence the existence of a state of mind. So before the commission of the offense, what was his mens rea, his motive? The motive preparation conduct section 8 में सीखे आपने. What kind of a preparation is made? What was going on his mind? This is all nobody reveals to you. Nobody reveals to you. No person wants to commit a crime. Sometimes it may be a spur of the moment or sometimes pre-planned conspiracy. It's an attempt to take some revenge. ये सब चीजें प्रूव करने के लिए a state of mind evidence can be led, such as intention. See that यहाँ पे example लेगा. Evidence you can lead to show that here his intention was to eliminate B because B had filed a suit for eviction and obtained a decree, and he was making preparation for execution and evicting him. And all requests and attempts and conciliation methods were failed, and he said, I will, मैं देख लूंगा तुझे. क्या? I will see to it, how will you execute? Threats he gave and went. He was in a furious condition. So you can lead his intention was not bona fide. His intention was mollified. From the very beginning, he was, from that day, the no sooner the civil court passed a decree of eviction against him, and he began harboring animosity. He began showing his mood changed towards me, his feeling towards me, his intentions were different. Similarly, in matrimonial offenses, at the time of the marriage, the relations were very good. We were very pally, things were very nice. सब कुछ अच्छा था. Lekin slowly, mother-in-law and he began demand. They came to know that the girl will say her father is a resourceful person, having several properties, several cash amount, and demands were made. The demands were made. The demands were made of a dowry demand. Cruelty was caused to the girl, and if you don't bring these items, and if you don't transfer, I intend to take a plot, and you have to get money from your parents. So यहाँ पे his intentions were not honorable. His intention was what? So when I did not honor it, and the girl, maybe for example, she began writing letters to her parents and to her sister. This is what they're demanding. And one fine day you found the girl's dead body was found. Then how do you gather? How do you prove? And this man says, I'm innocent. So the evidence can be led to show that here, immediately after the marriage, before the marriage, the scene changed. What was in his mind and his intentions were changed. So evidence can be led to that. Here, knowledge, then again, you can also need evidence with regard to knowledge. Who possesses knowledge of the commission of the crime? The watchman will tell you, in the middle of the night, I saw commotion. Huh? Huh? Two gentlemen had come, the drunken condition, one against the other. So he himself had knowledge. I know them. They are from a particular building in the locality. I know their names. So he has a knowledge about the fact that every day they come in the middle of the night. They come loafing around. They come in company. They bring girls in scooters, motorcycle. They drink liquor, commotion kiye, crime kiye, whatever may be. So the person who had knowledge about the particular fact in issue or relevant fact, may come and depose before the court of law. Somebody, it is immaterial that it must be a person who was present at the time of the scene of the offense. A person may be directly, indirectly known to them. Huh? Though a person has remote knowledge, even can come and before the court of law to state the nature of relationship between the two parties. They were best of friends. One of them eliminating the other. They were jealousy. They were rivalry. They were interested in one particular girl. Huh? She was not giving attention to the A only, B only. So as a result, there was a jealousy. There was a feeling of hatred towards him, and as an account of that, he committed the act of murder. So that evidence can be led. Even the girl can be examined to show that yes, I had knowledge of such a feeling. And then good faith and negligence. See whether good faith or bad faith. So you do certain transaction, in good faith, certain transaction malifiedly. You may say that here, in good faith, I handed over him my flat when he requested that there's a marriage in his family. He's my adjoining neighbor made a request. Ours is a old relationship for the last 30-40 years. He told me that please give me for 15 days. Your flat is lying vacant and you are going abroad. In good faith, I handed over my possession, believing that he will hand it over. आने के बाद शादी होने के बाद मालूम हुआ he has locked my premises and chained the lock. My good faith has turned out to be his bad faith. Yeah, he had ulterior motives. Then you are running around. Then he will take up the plea. No, the flat has been, I have purchased it. See the document. There was no consideration. I never received it. He has made bogus document. So you show that you had a good faith in giving him gratuitously or maybe for nominal consideration. Evidence could be led that here, in good faith, you acted upon. Otherwise, being a good neighbor, maintain a neighborly relation. And that evidence can be led here. Negligence and rashness. Now you can lead evidence that here Mr. A or Mr. B or C or D has been negligent. On account of the rash act of negligence, this accident has taken place. Salman Khan was in a drunken condition, the actor. He was negligent, rash driving in the middle of the night. There is a proof that the Havaldar, who was his companion, lodged a FIR. He was negligent. I had in fact warned him, don't drive in a drunken condition. So the evidence could be led to prove that persons who have seen his negligence, on the road ke upar how the gadi was moving in which direction, or the person who sat next to him, or the inmates out of which who suffered. Of course, people who died, they cannot come and give evidence. People who suffered injuries, they can give. Instead of driving the motor vehicle on the road, he came on the pavement, negligently driving. So evidence can be led to show that there was a gross act of negligence. In negligence has resulted in this particular act of the crime. So evidence can be led to show that here somebody had a negligence and rashness. So this got 304A के अंदर आप देखेंगे, this has been used. IPC खोल लीजिए आप. You come to know, I will connect you to the right section for that. 304A, causing death by negligence. Whoever causes death of any person by doing any rash or negligent. देखो यहाँ पे rashness भी आ गया आपको. Section 14 के अंदर you are entitled to lead evidence of negligence and rashness and not amounting to culpable homicide shall be punished with imprisonment of the description for a term which may extend to 2 years with fine or both. This is generally for India. For the state of Maharashtra, this has been amended. You know that here the government of Maharashtra has amended section 304A where 10 years of punishment can be given. All of you know that here. Salman Khan ka case मालूम है आपको. All of you know that the appeal, The appeal is pending in the High Court. I do not want to comment upon it. Till what happened in the High Court, I can give you in this matter. समझे ना आप? So this is the even then abetment to suicide also पढ़े आपने 305 306 वहाँ पे भी how the persons abet that is not important. Let us confine to 304A के अंदर ही 304A is the finest example of rashness. Motor vehicle offences under the Motor Vehicle Act, under the Central Motor Vehicle Act and the Maharashtra Motor Vehicle, all state vehicle act you contain. So the one of the matters I recently appeared, which you must be, I think I circulated to you, the gentleman was driving rashly and the Havaldar, traffic Havaldar asked him to stop the car. He did not stop it. Sanjana, he did not stop the car because because of the SOP which is under the Epidemic Act. The government of Maharashtra and central government has imposed certain restriction whether you should be wearing a mask and particulars precaution. ये gentleman was not taking precaution and the हवालदार stopped him. नहीं रोका उसने जाने को. हवालदार ने क्या किया? जम करके बोनट पे बैठ गया. You know that case. This happened in Andheri DN Nagar police station के पास. The DN Nagar police station, immediately he was driving rashly and negligently. And the Havaldar asked him, please wait, don't go. नहीं गया उसने. And the video has been circulated. International हो गया matter. It is still there on the YouTube. And everybody were abusing him, cursing him, and police wanted to invoke, they have invoked 304A against him, and also wanted to invoke 307 against him, attempt to murder. And he had applied for a bail at the time he went to the court. It was rejected. Then thereafter rejection ke baad, the parents came to me whether you can help us in the matter because I was not available at the time when they came first. Then I moved the matter before the court of session. The court of session asked me a serious question. Mr. Shah, it is a very serious act, a public servant, and this man is attempting to commit a very rash act and he would have killed him. And I told him, and judges के लिए when obtaining such interim orders, discretionary orders, as a young lawyer, you should know that you have to be very polite and don't justify. Of course, the act of the police, the commission, the gentleman police Havaldar sitting on the bonnet is also not correct. First of all, our client, the gentleman, the driver, he should have stopped the car. So he did not stop it. Actually, he is committing an offense under 169 of the Motor Vehicle Act, which is a penalty under section under that 1,000 rupees ka penalty hai. It's a penalty. Havaldar normally takes the signature. गाड़ी का फोटोग्राफ खींचेंगे, पेचेंगे, पे करो. That is a penalty imposing sanction. So यहाँ पे हवालदार took it very seriously and got carried away. And he jumped into the he jumped into the bonnet of the car, and the gentleman, without stopping the car, 2 kilometers को घुमाने लगा. Very rash act, very rash and negligent. Whether intentionally, unintentionally, we don't know. And he is an officer. He's come from a good family background. The gentleman who did it, he is a highly qualified person. Highly qualified person doing his very painful decision. So the learned judge, when he asked me in the court of session, Mr. Shah, you are appearing in this matter. What he has done is correct. I told him, what he has done is not correct. If I had told him correct, the High Court judge will not give me the bail order. Though I just told him he should not have done it. But at the same time, my lord, a very unfortunate matter. It was a case of a rash and negligent driving, and which is an offence under the provisions of Motor Vehicle Act. A penalty of 1,000 or 2,000 rupees could have been imposed, and the Havaldar could have taken the number. But unfortunately, the Havaldar took it very personally, which is very unfortunate. It shouldn't have happened. But in such matters, then relying upon the Supreme Court judgment in Arnesh Kumar's case, where the offence is not very serious, isn't it? Keeping a person in detention is unwarranted. It may be a rash act. आवाज क्यों आ रही है देखिए कुमार आशुतोष B42 के अंदर आवाज आ रही कुछ आदित्य भाई B में कुछ प्रॉब्लम है
Tap to accept the receiving phone, and I've just transferred 3 huge video files to the bedroom. Here's what to do. You go to any 5-star or 7-star hotel in Delhi.
Yeah. Are you all able to hear me now? Ashutosh? You all can hear me now?
Yes, sir.
Yes.
sir.
So I very politely put to the learned judge, my lord, yes, very unfortunate, it shouldn't have happened. At the same time, the police officer should have been cautious in the interest of his own health. He should not have shot on the bonnet, and it's very unfortunate. And I'm not saying, but sympathetically asking, I'm confessing it's a rash act. If I told him it's not a rash act, the judge would not give me a bail. तो at this motor vehicle act में penalty है 2000 रुपए की. Definitely it will not come under 304 ये. 304 ये लगा दिया उन्होंने 10 साल की punishment है. And he said triable by the court of sessions in Maharashtra. You know that year. Then fortunately, Arnesh Kumar's versus judgment came from a rescue, which the Supreme Court clearly said that punishment, the offences, such matters, the court should be liberal in the matter of granting bail. The various Jogendra Kumar's case judgment, all these judgments you should remember when you are practicing advocate. Please make a compilation and keep with you because you may forget it and bana ke rakhiye. These all help you. So यहाँ पे I did confess to the court there is a rashness. There is negligence on the part of my client. So ultimately in the trial court, there was no intention to kill. Kill that, yeah? There was no intention. There was no intention at all. He was petrified. The moment the Havaldar sat on the bonnet, I got scared and petrified. I don't know what to do. My state of mind. That is the kind of evidence you will be permitted to lead. Sanjana? So this section 14 permits you to lead this kind of evidence here. So negligence and rashness. Then देखिए यहाँ पे again you can lead evidence with regard to ill will or good will, whether in commission of the act, whether your intentions were honorable or malified. Huh? Ill will, that is ill will. You had pre-planned the conspiracy to commit this particular act. तुम जानबूझ के मारने वाले थे उसको हवालदार को. Your intention were not at all bona fide. You had made up your mind to eliminate him. So it not only becomes rashness and negligence, it is also intention to kill, attempt to murder. 307 लग जाएगा उसके अंदर. So if the prosecution proves
Sir, I have a question. Can I ask you?
Any problem?
Hello.
Yes.
I have a question, sir.
बोलिए.
So in the case you said that section 304A was imposed, right?
Yes.
So did the Havaldar die?
No, he did not die. attempt to murder में कोई मरता नहीं. Only 302 में
Sir,
मरता.
but 304A speaks about causing death by negligence. So that's why I was confused.
Yeah, they have here 304A causing death by negligence. I'm sorry. The section with the section which was imposed was there was no death took place. 30 I'll just tell you. Whoever causes death of any person of doing negligence. What the section which was approved? Yeah. 307 they had imposed. 307. I will just check the section. I remember it, they had imposed 304A, which is wrong, is not applicable. 304 में, एक minute. 307 attempt to murder लगा थे उन्होंने. 307 is a attempt to murder. Please note that, yeah. 307 was a invoke, and उसमें I do not know for what reason they have invoked. It is wrongly invoked. 304A, I remember they had invoked it because 307A will not be applicable unless death take place. But to maybe for invoking the provisions of section 309, they were invoking rashness and negligence, and also under the provisions of Motor Vehicle Act, isn't it? That is the punishment. So I'm only trying to explain to you, evidence can be led. Now, in the case of Salman Khan's evidence, death has taken place. isn't it? 304A was invoked. The section is correctly invoked. Whether it was intentional, non-intentional, that the court will see in the trial. That the court will see. So that means ultimately in the trial court, in the prosecution, you will be permitted to lead evidence. But the trial court in Salman Khan case convicted him on the ground that year. The Havaldar who was given to him as a bodyguard was the informer. He went to the Bandra police station, lodged a FIR. Pursuant to his FIR, the learned magistrate took cognizance of the matter, Bandra Magistrate Court. Now, at the time of the taking of the cognizance under section 202, the learned magistrate recorded the statement of the Havaldar who subsequently died. Now, the question arises because at the time, the magistrate who records evidence under section 200, the verification stage it is called, that is recorded by the magistrate for the purpose of taking cognizance of the crime, cognizance of a complaint, whether I should proceed or not. The accused person is not required to be called. He is not called. Section doesn't say that issue notice to the accused. There is no such notice. The subject to satisfaction of the magistrate, he can say that here, I am satisfied that I would like to take cognizance. Then he will say, he will put the complainant witnesses in the box, number one. If he is not satisfied under 200, he will invoke section 202, which permits 202 CRPC either to hold inquiry by himself or through another magistrate. Or thirdly, he may direct the police officer to investigate the crime under 156(3) CRPC. This is how the procedure takes place. Now, the session judge convicted Salman Khan on the ground that there was a evidence of the gentleman, the Havaldar, before the magistrate at the stage of verification that is sufficient to convict him for the offense. He had given evidence. He drank 9 packs of alcohol in Juhu ke andar, koi pub ke andar pee ke aaya, and he was he drove down and mauled the 5-6 लोगों को मार दिया उन्होंने. Whatever it is, that was the session judge was in error. Why is in error? Because for convicting the accused person under 304A, he is solely dependent upon the evidence of the Havaldar who gave before the magistrate an FIR. But the evidence given, the verification statement given by the Havaldar under 200 is outside the purview of evidence. It cannot be used under the Evidence Act unless the person who gave evidence was cross-examined by the other side. Now, the relevant section in that regard is, for using the judicial proceeding and the statement used by the person in earlier cases is number 1, that is section 33 check karenge aap Evidence Act. Relevancy of certain evidence for proving in subsequent proceeding the truth and facts therein. So the earlier proceedings were in Bandra court. First information report, statement of the witness under 162, and the deposition of the Havaldar under section 200 CPC, TRPC. Now, when you open section 200, the learned magistrate records the evidence. Just see that 200 CRPC खोल लीजिए. Yeah. See, examination of a complainant. A magistrate taking cognizance on offense on a complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of the examination shall be reduced to writing and shall be signed by the complainant and the witness and also by the magistrate. So this is actually evidence for the purpose of the Evidence Act. 200. So I'm coming here. Then 200 के बाद आप section 33 check करो. So this is the evidence of the gentleman, the Havaldar, who gave before the magistrate. Of course, this is ex parte without notice to other side. Other side is not present. Like in civil cases, you have to give the plaintiff give notice to other side for obtaining orders. ऐसा नहीं criminal cases के अंदर. Magistrate has a heavy role to play. He must be satisfied that the offense is committed. ये होने के बाद ये, you know that here that gentleman died unfortunately, the Havaldar. Now you want to use the session court में is a session triable case, isn't it? 304A is a session triable offense under the scheme of the CRPC. You all know that here. 304A मैं बता देता हूँ. When you open the CRPC, is 304A is a session triable case. Death by causing so magistrate of the first class. In Maharashtra, it is triable by the court of session. So the session judge has used section 33. 33 of the Evidence Act खोल लीजिए दोबारा. See, relevancy of certain evidence for proving in subsequent proceeding. The first proceeding was before a magistrate under 200. Then after the matter was committal proceeding took place. You know that no? When a magistrate comes to know that particular offense is triable not by magistrate, it is triable by the court of session, he will send the matters to the session, that is committal proceeding under 207 CRPC. वो मैटर भेज दिया गया और ट्रायल मीन दैट सेशन ट्रायल स्टार्टेड कंडक्टिंग बिफोर द कोर्ट ऑफ सेशन under section 225 onwards in the CRPC. So evidence may at that stage the learned judge call for the record, entire record. So 33 was pressed. Number C, relevancy of certain evidence for proving subsequent proceeding the truth of the fruit of the state. Evidence given by a witness in a judicial proceeding. Mean, for example, evidence given before a magistrate, a judicial proceeding, or before any person authorized by law to take oath, is relevant for the purpose of proving in a subsequent judicial proceeding. Subsequent judicial proceeding is after remand going to the court of session or in a later stage of the same judicial proceeding. So the earlier statement of a person, either in the affidavit or evidence given before the court, they can either in the interlocutory stage, you made certain statements. At the trial, you can be put into question by the counsel, the questions, certain questions which may be contradictory in the same proceeding. The truth of the fact which is states when the witness is dead, cannot be found, incapable of giving evidence, is kept out of the way by the adverse party, or his presence cannot be obtained without the amount of delay, expenses which under these circumstances the court may consider reasonable, unreasonable, cannot consider unreasonable. So the condition precedent is that here to invoke section 33, the person, the witness must have been dead or he is unable to come to the court for maybe illness, maybe migrated to foreign country, not available, old age hai, or other side is prevailing upon not to produce him before the court, A reason, B reason, or discretion is available. But this can be only used provided number one, that the proceedings were between the same parties to the representative. So Salman Khan was the same person before the magistrate and his own case is committed to court of session. So this will apply. Now, number two is important, that the adverse party in the first proceeding had a right and opportunity to cross-examine. So Salman Khan's lawyers did not have the opportunity to cross-examine the Havaldar under section 200 examination because section 200 does not permit the accused to participate at that stage. So यहाँ पे court of session committed wrong. The High Court said 33 could not have been invoked. So the all evidence which was led by the given by the Havaldar with regard to rashness, negligence of Mr. Khan becomes of a zero value. That is why the appeal is admitted in the High Court. So the media on the session judge has with great respect has passed the order on the basis of the media trial. You cannot pass orders on media trial. A person may be or legally. That just because media public do not know, public get carried away. So you have to invoke the provisions of law properly. So the session judge, whoever was, with great respect, has not taken into consideration section 33 proviso, the second limb. Had it been, there were maybe other factors, other grounds, other evidence available to him. He could have, they could have been bystanders, there many other. But to rely upon the evidence of a dead man, that is of a Havaldar, at the verification stage under 200 and his Panchanama, and to be the sole basis of the evidence for conviction, is with great respect wrong. Okay, that is why the High Court rightly admitted the appeal, and probably he'll also be acquitted. Okay, because the charge of rashness and negligence does not stand to be proved, but the Supreme Court, when substantial amount he has deposited, normally he has taken, it's basically a motor vehicle offense, rashness. Even under the provisions of the Indian Penal Code, if you take up the plea, it is a 304 mein aayega. Punishment not amounting to murder, it is where imprisonment. Oh yeah, sorry, the offense which was invoked was 304, not for any punishment for culpable homicide not amounting to murder. This is the Salman Khan case. यहाँ पे 10 years है देखिए. ये 304 ए भी उसके अंदर उनको इन्वोक किया गया. Okay, according to me, in the case of the gentleman Andheri, 304A was wrongly invoked. So one of the students said rightly 304 में death must be caused. यहाँ पे death ही नहीं हुआ था. Maybe intention to cause death. Maybe that is an offense that will come, attempt to cause that section that will come under 511 of the Indian Penal Code. वो देख ले यहाँ पे 511 भी come to know. 511 can be introduced of the Indian Penal Code in that regard. आप चेक करेंगे 511 attempt to do the act will come into play here. Oh, that is not the case. That was not the that is only the police officers in a heat of moment have done this, according to me. Otherwise, a non-substantial ground it is. That is what one of the arguments, that no death has taken place, and when no death takes place, you cannot invoke this section. And maybe they have not. In fact, the police officers could have succeeded had they introduced 511, according to me. That is the punishment for attempting to commit offense punishable with imprisonment. So 511 was not invoked, fortunately. And they had wrongly invoked section 307, attempt to commit murder. 304A was totally out of question. That was also one of my arguments before the court. Death has not taken place. So 304A cannot be invoked in the matter here. So at the most, they could have invoked 511, which was not the question. Okay, that evidence can be led under the provisions of section 14 of the Evidence Act. So ill will and goodwill. So you prove that particular act has been done with good intention or bad intention. The offense, so you have a right to lead evidence. It is a ill will or goodwill. So these are all, you have been caught, or the accused has been caught. Red-handed in the matter. Well, I had no intention to steal. I just only happened to put my hand. I got it here, and I did not know whom it belongs to. I just took it. It's a bona fide belief. The goodwill, goodwill towards any particular person. I hold this man in highest repute. There is no question of committing any offense against him, of theft or any other person, any other offenses. समझे ना आप? So you lead evidence with regard to the goodwill and ill will towards any particular person, or showing the existence of any state of body or bodily feeling. So what was the evidence you are permitted to lead, either in examination chief or cross examination, both in criminal prosecution as well as in civil cases? What was the state of body? So the state of body evidence you also learned under the provisions of section 8, when the the provisions of about the state of B's health, that is illustration C to section 7. The question whether a poison be the state of B's health before the symptom ascribed to poison and habits known to which afforded an opportunity for the administration of the poison are relevant. So the state of body or bodily feeling. So you may ask a witness bodily feeling. He may say that I recognize the accused person from far. So questions may be asked in cross-examination. What was the time at the time? Whether you are used to taking intoxication drinks in the night, middle of night timings. So you can put in cross-examination, look here, at the time you are totally intoxicated. And you are not in a good frame to recognize where is what. And you are a got up witness by the prosecution. You had no energy. You did not know how many pecks you had consumed. You can ask him in the cross-examination. There is no. There are many lawyers ask this question. You read this here. To discredit a witness. You could not have seen anybody. You were not in a proper state of mind at all. You were in an intoxicated frame of mind. Such evidence can be allowed by the court are relevant when the existence and of any such state of mind, body or body feeling is an issue or relevant fact. So this evidence you are permitted to lead. Illustration से मालूम पड़ेगा, मैं बताऊंगा. What are the various other cases? Number 2, see explanation. A fact relevant as showing the existence of a fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to particular matter in question. So this particular man, the witness, is suffering from schizophrenia. He is not able to understand. For 8 to 10 hours, he is unable to understand. There are medical doctors giving opinion. It's an acute case of schizophrenia, mental condition. But not if doctor says no, he's half an hour he is okay, another half an hour not okay. It's a general condition. It must be an acute condition. Reference to the particular matter in question is not generally. It must be persistently. A general and vague evidence or narration which is not definite, a plea cannot be taken up. Similarly, like under the CPC also, the denial cannot be general and vague and evasive. It must be definite, specific. So here evidence with regard to existence of a state of mind must be definite. I am suffering from insanity, the accused person. For the last 15, 20 years, he is under treatment. He has not recovered. He did not know the nature of the act. He is under the treatment. Under the Indian Mental Health Act, you are taken certificate. Doctors were examined. And your neighbors were examined. Family members were examined. So that's a definite evidence with regard to the existence of state of mind. Between the spouses, adultery is an offense. Case is filed in the family court or a civil court for a decree of divorce. That the husband has been having adulterous relationship with the co-respondent. Their relationship has been going on for several years. The wife will say, I requested him several times to stop it. No, he's not stopping it. She produces various letter, intimacy, photographs. Huh? Then he will take up the plea. No, we are just college friends. Nothing wrong in it. We had not done anything wrong. My relations are with her, platonic relationship. It is my nature to be very friendly type, flirtatious type, but I did not have the such kind of relationship. So his general behavior, his state of mind, that evidence can be led by both these sides in the matter. Okay. Explanation 2. But where upon the trial of a person accused of an offense, the previous commission by the accused of the offense is relevant within the meaning of this section, the previous conviction of the person shall also be relevant. He is a habitual offender. He has earlier committed similar offense. He has earlier committed earlier offense. Number 1, produced several FIRs in the locality. And the court of sessions or a magistrate had convicted him for 5 years. So the judgment of the earlier courts are relevant and admissible for the purpose of section 40. Open करें आप. Section 40, 41, 42, 43, they deal with previous judgment relevant to bar second suit or a trial. This is for res judicata under 11 and section 300 of the CRPC. Double jeopardy के लिए section 40 can be used. 41 can be used, which I read it to you, for conclusive evidence. Matrimonial cases, probate cases, admiralty cases, insolvency cases. A final decree pass, a judgment of the court is a conclusive evidence. You are not required to lead evidence in rebuttal to disprove it unless a fraud takes place under 44. 42 can the relevancy in effect of judgment, order, decree other than those mentioned in 41. So 42 permits to show that this man was previously convicted. That is to show that here evidence can be laid. Of course, there are certain section the in criminal cases previous good character bad character के बारे में देखे ना, पढ़े आपने. Previous bad character not relevant except in reply 54 के अंदर. Character की बात अलग है यहाँ पे. You will be permitted to lead evidence to that he is a habitual offender. The court can presume in the present matter. Of course, criminal law is not based on presumption. To a certain extent, the judicial officer can draw presumptions under 114. The existence of a state of mind, this man is a habitual offender, he is incorrigible, is revealed from the fact that he has committed such offenses in the past. He was prosecuted by several police stations in various courts. So you will be permitted to bring before the court, for the purpose of this section, the previous charge sheets, FIR, the statement under 161 of the previous witnesses. You can lead them to show that his state of mind. So that cannot be, other side cannot take up the plea that. Of course, court is not going to convict a man merely because he was convicted in the earlier one. Earlier crime he may have committed, here may not have committed. Or attempt is made to commit it, or he was maybe innocent. But evident, the court will consider matters before it. That is what the provisions of section 3 आपने सीखा ना, ये it is not evident. Proved के अंदर a fact is said to be proved when after considering the matters before it. So it will be a matter before it, may not be a direct or best evidence before it. It is in fact a matter before it. Section 40, 41, 42, 43 के judgment is a matter before the court under section 3 when proving, proved, disproved and not proved. So the court has to consider the matter before it. It's a matter. So to ascertain the state of mind, body feeling, intention, knowledge, negligence, illness, goodwill, ill will, bona fide, otherwise, all his attributes of the accused or the complainant, दोनों के भी आएंगे, witnesses के बारे में भी आएंगे. So this is the section. Now come to the illustration, because your examination questions will be asked based upon the explanation and illustration, which you must know that. Illustration A. A is accused of receiving stolen goods, knowing them to be stolen. It is proved that he was in possession of a particular stolen article. So he is committing an offense under 410, 411 IPC. So those of you just open 410, देखो आप, these are the offenses relating to stolen property. 411, dishonestly receiving stolen property. Illustration A में आएगा, whoever dishonestly receives or retains stolen property, known or having reason to believe that the same to be stolen property shall be punished with imprisonment for its inscription. So you know that your chain has been snatched while traveling in train. Mobile phone has been snatched by local train. पुलिस को इंफॉर्मेशन है, ये गैंग ऑपरेट करती है, दे गो एंड सेल इट इन द लोकल मार्केट, शोर बाजार में, सो एंड सो वेंडर परचेजेस इट. दीज आर द जेंटलमैन, पुलिस के पास ट्रैक है, दे नो दैट. सो द रिसीवर ऑफ द स्टोलन गुड इज कमिटिंग एन ऑफेंस. सो accused is he the person receiving stolen good. Then देखिए, the fact that at the same time he was in possession of many other stolen articles. तो शॉप में, ज्वेलरी शॉप में देखेंगे आप, there are many jewelers who accept this kind of purchase from the market. So, 1000 rupees चीज आपको 100 रुपए में मिलती है, क्यों नहीं बेचेंगे? Gold is now 40 to 45,000 rupees per kilogram. If the thief is selling you for 10,000, you'll be happy to take it, isn't it? 10,000 में लेंगे आप, 40,000 की माल बेचेंगे. पुलिस हैज ए, you come to know, track करेंगे, पुलिस पकड़ने के बाद he will make a confession under section 27. After stealing, after committing the offense of robbery or a theft, where is the article? I sold it to the local jewelry shop situated at the ABC place. So the police will go there and come to know that उसकी जगह में इसके पास lots of counterfeit coins हैं, isn't it? Too many. So he is habitually dealing in stolen property. 413 आप चेक करें IPC. Whoever habitually receives or deals in property which he knows has been stolen, believed to be stolen property, shall be punished with imprisonment for life or with imprisonment description, X into 10 years. So it's a very serious offense. Triable by the Court of Sessions. Please note that here. Because it's a triable by the Court of Session is made very serious offense. So यहाँ के अंदर, this is what number, ये accuse is illustration ये के अंदर, he has to lead evidence. The goods which are in my possession are purchased by me. 114 का illustration आप check करें, he has a right to write rebuttal evidence, isn't it? A rebuttal evidence to show that I am not a thief. 114 के अंदर आप देख लीजिए. Yes, that a man who is in possession of a stolen good after theft is either thief or received the goods known them to be stolen unless he account for possession. If he is in a position to account for it, he is the owner. If he is unable to account for it, he is the thief. He is the receiver of stolen property. Say habitually dealing in the property. So evidence can be led to show that here, this man, there is a intentional knowledge on the part of the accused person to receive these stolen goods and make business out of it. And he has full knowledge. He knows his customers, the land grabbers, the petty thieves in the train, the mobile, they bring in the mobile. So he has purchased from them in not good faith. It is intentionally to make money, isn't it? It is not even a negligent act. It is a deliberate act. So evidence can be led to show under this provision. Number B. A is accused of fraudulently delivering to another person a counterfeit coin, which at the time when he delivered he knew to be counterfeit coin. So currency आजकल market में देखते हैं आप. Lot of counterfeit coins are there. Now, this is actually an offense under section, I think 489. देखो IPC का 489. Oh, counterfeit coins का yes, counterfeit 489. Yeah, 489A चेक करें आप. ये आ जाएगा 489A counterfeit coins. 489B. These are all session tribal cases, serious offenses punishable for life imprisonment भी इसके अंदर है. देखिए counterfeit coins के sections you should know the IPC के अंदर. Making marks, falsification of account, marks. Yes. Yes. Trademark वगैरह का भी है. We are using this for our purpose. That is it. Yeah, for our purpose, the relevant section 489C. 489C, when you open, is the relevant section 489A, B, C. Possession of forged and counterfeit currency notes or bank notes. Whoever has in his possession any forged or counterfeit currency note or bank notes, knowing to have reason to believe the same to be forged or counterfeit, intending to use the same as genuine, or he may use as genuine, shall be punished with imprisonment for a description for a term which may extend to 7 years, or fined with both. 7 years punishment है इसके अंदर भी. So the evidence you can lead to before the court, the fact that A has been previously convicted or delivering to another person, genuine wanton court relevant. So you can obtain a decree and judgment of the Sessions Court. He was previously convicted by Pune court circulating money, bogus money. Now in Mumbai, he is doing it. I have obtained the certified copy. And in fact, the Pune police has come and given evidence in the prosecution. Isn't it? The certified copy of the judgment and the order of the Pune court convicting him may kindly be taken on record, which can be taken by the court pursuant to the provisions of explanation 2 to section 14 and read with section 41, 42, 43. The previous conviction is material to show the state of mind to show the bodily feeling of a person and he is a habitual offender. Then C पे आ जाइए, सिर्फ C पे आ जाइए. A sues B for damage done to A's dog. A sues B for damage done by the dog of B, which B knew to be ferocious. So इसका कुत्ता बहुत एकदम aggressive है. Your neighbor has a very aggressive dog, who is barking. और नए आदमी को देखेगा तो पकड़ लेगा उसको, and he will bite. The fact that the dog had previously bitten XYZ and they had made complaints to B are relevant. So you are claiming damages or you filed a suit, a criminal prosecution against B for negligence, or also claim damages in the civil court on account of the biting of the dog. So you have a right to lead evidence of the other witnesses to show that that previously this dog had bitten XYZ. You can examine them as witnesses to prove that it is the Mr. The accused person has deliberately let him loose. Let him loose. There is a rashness and ill will, negligence on his part. He is bound and liable to compensate me for the loss caused. I was hospitalized and took medicine. I was injection lena pada, maybe operation karna pada. My leg was bitten. I suffered losses, maybe about ₹1,00,000. So mental torture ke liye bhi, agony ke liye bhi I am claiming a damages to the extent of ₹5,00,000. So in such a claim, you will succeed in the matter. Then the question is D. The question is whether A, the acceptor of a bill of exchange, knew the name of the payee was fictitious. This is under the Negotiable Instrument Act, fraudulent transaction taking place, banking transaction. Easily we have that. Yes. Presumptions arising under 118 of the Negotiation Act. The fact that A had accepted the bill drawn in the same manner before, they could have been transmitted by him, by the payee, if the payee had been the real person, is relevant as showing A knew that payee was a fictitious person. So there was a knowledge. This is a evidence to show that A had knowledge. The amount which is sought to be transferred, evidence of a knowledge, पहले की previous transaction में इसने किया था उन्होंने. अभी having done it, having possessed the knowledge that he can, the plaintiff or defendant can show that here there is an acquiescence on his part. The conduct shows that here he had knowledge about it. There is a waiver on his part. So that evidence can be led in civil cases, commercial cases, when you are filing a suit for summary suit or regular suit in this regard, or claiming damages for injury caused in this regard. D. A is accused of defaming B by publishing an imputation intended to harm the reputation of B. A is accused of defaming B, publishing imputation. 499 IPC defines what is defamation, isn't it? Defamation attracts both penal offenses as well as civil offenses. In law of tort, you can claim damages. Okay. The fact of previous publication by A respecting B, showing ill will on the part of A towards B, is relevant as proving A's intention to harm B's reputation by a particular publication. This man, the accused, is in the habit of indulging in a campaign of vilification, bring my reputation and my family reputation in disrepute. He has been writing articles upon article in the press, isn't it? Or previous articles can be shown before the court of law to show to prove that his intentions of the accused are not bona fide. They are malicious. They are malicious, and he doesn't. They are not with the intention to. It is not a goodwill. It is a ill will. He has ill will. He has animosity towards me and my family. So he is coming within the definition mischief of 499, 501, 502, 503 IPC publication of the defamatory material is an offense. And he has caused me substantial loss by publication of this article, which has gone all throughout the globe. I have friends and relatives. My reputation, my family reputation has been brought down in the estimate of others. The entire newspaper, the internet speaks about this. I'm being ridiculed. So I'm claiming damages. Now, recently, Mr. Wankhede, the one of the officers of the government, has filed a suit against the minister that he is publishing defamatory article and defame my family, and moved the High Court, isn't it? Defamatory articles, defamation के अंदर फाइल किया उन्होंने, claiming damages running into several crores of rupees. Each and every day, the concerned minister or MP, whoever is, or a MLA, public officer, who claims to be the spokesperson of a particular party, political party, he is indulging in a tirade against my family. A campaign of vilification relentlessly each and every day. Highly defamatory. My reputation has been brought down. So the matter went to the court. You all know it's coming in newspaper every day. It has been coming. Prohibitory orders, one single judge took up the plea that he is a spokesperson. He is speaking on behalf of his party. It is not defamatory. The division bench took a different view, but it cannot be done. Then ultimately, both the parties entered into a consent terms that I will not do further publication, but I will only speak with regard to he's a public servant. I have a right to speak about a public servant. So it's coming under the explanation A, B, C, D of the 498A. In good faith, if you speak, without ill will, it is permissible. It is not defamation. आप illustration check करेंगे आप section 499 is very important. To ill will, good will के लिए 499 check करो आप 499 के explanation. Explanation 1, 2, 3. See, in imputation, defamation makes imputation concerning us, explanation, imputation, illustration check karo. Z, an honest man never so and so, one of the exceptions is defamation unless illustration A, honest man never stole B's watch intending to cause it to be believed. Leads to defamation unless it is proved within the exception. Number one. B, A asks who stole B's watch. A appoints Z intending to cause to be believed that B stole what? This is defamation unless it falls in any of the exception. So this is not ill will, this is not a good will, this is ill will evidence. A draws a picture of Z running away with B's watch, intending to be believed that Z stole B's watch. This is defamation unless it is within the exception. Then first, imputation of truth with public good requires to be made or published. It is not defamation. This is what the minister took up this plea. It is not defamation to impute anything which is true concerning anything. If it true for the public good, for imputation should be made, published, whether or not. It is for the public good, so on so forth. So the minister has taken the view, whatever I am reading, stating, is a public servant. I would like to tell how the public servant can amass So much wealth, where he got it from? अभी पेपर में आज क्या है, आप थाना में इसके अंदर he has a license which is misusing, वो अलग बात है. That whether it is done with goodwill or ill will, we do not know. So this evidence you can show to illustration here, the imputation are in a public good requires to be made published. Then another illustration, second exception, public conduct of public servant. It is not defamation to express in good faith or opinion whatever respecting the conduct of a public servant in discharge of his public function, respecting his character to discharge. You can say that I am highly disappointed with the government of India's budget. It is not defamation of the ministry. You may say, as a citizen of India, I am highly disappointed. The rates are gone up. The taxes are increased. It's a very poor budget. You may write a editorial column में बहुत से लोग लिखते हैं. So, criticizing the government or a public servant in public interest is not a defamation. And as a enlightened citizen, many good senior lawyers, many enlightened citizens, even senior journalists, and many people say that the judgment of the Supreme Court in this respect is a very poor judgment. It is uncalled for. The Supreme Court says that it is not defamation if it is honestly and our judgment is criticized without any ill motive. What is ill motive? Ill motive, the Supreme Court will decide it. Under the Contempt of Court Act, if you speak against the Supreme Court judges and anybody, you had it then. They will invoke the provisions of Section 15 of the Contempt of Court Act, which is very serious offense. But this particular need isn't if it you but the Supreme Court itself has been candidly saying if my judgment is criticized, you may take up the plea. The judgment given by the full bench judgment in the Kerala case that women can also enter the temple is discriminatory, and many of the gentlemen from South India they do not appreciate this. The judgment is very bad. Many of them are कुछ भी बोल देते हैं, isn't it? But you should criticize in a respectful manner, in a dignified manner. Language, you have no right to run down the judiciary or attack the judge personally, viciously. And many people, you may have difference of opinion and right to privacy के बारे में and Babri Masjid के बारे में. Many Muslims may not agree that the judgment, many of them have said it is an injustice to us. Our mosque has been demolished. The Supreme Court has not given any finding with regard to the existence. Very unfortunate. So this kind of feelings are outburst. So Ayyappa temple ke baare mein bhi Kerala mein the ladies cannot go and during ministerial period and lot of criticism you will see that here. So it is a public conduct. A ministers, I gave you an examples of the budget of the government of India or a minister passing the order, prime minister's statement in the election campaign. And many of them during election time, बहुत सारे speeches देते हैं. So you have a right to criticize. Press is criticizing. Many people are criticizing. Even the prime minister is not left here. When you go on the, I was watching yesterday YouTube. One of the gentlemen, Bhanu Mehta, was very critical of the government. But his critical stand is not defamation. These are his honest views. There are many people who praise the government. Whatever reason, people have a right to hold opinion of a particular party, particular government, minister, and you have a right to criticize. If the criticism is not malicious, it is not out of the range of limits of decency, this is not defamation. So this is Section 14. Essentially, you invoke for this purpose explanations in Section 499 के लिए जबरदस्त काम आएगा आपको. Please note that when you are conducting a trial for defamation ही काम आएगा. The third is the conduct of any person touching any public question. It is not defamation to express in good faith any opinion whatever respecting the conduct of any person touching any public question, respecting the character as far as the character appearing. You may say that our professor in the government law college, according to me, has not settled proper question. Difficult question. Students have gone crazy. That is not, it's a bona fide criticism. But if you attack taking a name deliberately, that may be unwarranted. If you general a general assertion that students were hapless in the matter, had no clue, and the question is out of syllabus. According to me, it's a bizarre question that you can say. You have a right to say that university is not following the its syllabus, isn't it? A particular professor is also not conducting the classes as required. You have a right to make such a such a, what do you call it, whole opinion. There is no such embargo. Particular minister is not with great respect discharging his function as he should have done. ये करेंगे तो आप कुछ नहीं. There is no defamation. That how the evidence section 14 will come into play. That here the evidence, the assertion, my assertions were in good faith. My assertion, I had no ill will. It is with as an honest citizen of India, I express my indignation with the state of affair, what is happening, that I am not getting justice. The Supreme Court or High Court, even the lower court, they have not examined the witnesses which ought to have been. The learned judge has passed order which is without following the principles of justice, equity, and good conscience. You have a right to, in the appellate forum, you can say that, make a ground of appeal. With great respect, the trial court has committed an error of law, error of fact. The learned judge has committed an error by not giving me audience. The learned judge has prevented me from leading evidence. The judgment of the learned judge is not sound in accordance with law. It is totally perverse. You may say, you use this word perverse, but you cannot use the word the judge was dishonest, judge has been bribed. Nahi, bilkul nahi. That is defamation. Please note that. Don't use the in appeal or writ petition harsh words against the judges, trial court judges, or any judges who have tried your matter where you never got justice. Be respectful in your criticism. Be respectful in your grounds of attack. Please don't. Otherwise, what is it? There is a thin line between defamation and goodwill and ill will. That you should know. The exception, the pure illustration to the section 499 by heart karke rakhiye aap. As a good student of law, as a good lawyer, and a good arguing counsel, even as a solicitor who prepared the case, will be good in his job if he remembers this section while preparing a case for defamation, both in civil cases, in criminal cases, when you're conducting. If you don't know the explanation and if you don't know the provisions of section 8, you will not, and 14 of the entire Evidence Act, rather, you will not be able to prepare a good case. You will not be in a position to conduct a trial or an appeal or writ petition. So bear in mind, this is how it helps you in this regard. Okay. Then come next to next illustration. Publication हो गया अभी. That is illustration E. Yeah. Then उसके नीचे है, the fact that there was no previous quarrel between A and B, and A repeated the matter complaint as he heard it, are relevant, showing that A did not intend to harm the reputation of B. So you have a right to lead evidence. I had no intention to harm him at all. It was done in good faith. In good faith, evidence is covered under section 14, isn't it? So you cursorily mentioned it. You never had any intention. Yes. F पे आ जाइए अभी. So illustration E is the finest example for defamation cases. F पे आ जाइए. A is sued by B for fraudulently representing to B. A is sued by B, so B is filing a suit against A. A is sued by B for fraudulently representing to B that C was solvent. So I tell you, I am Mr. A, you are Mr. B. I am telling you, Mr. C, our Kumar, is a solvent person, rich man, पैसा बहुत है इसके पास, अमीर आदमी है. Whereby being induced to trust, who was insolvent, suffered losses. So you can do business with him. He's a rich man. I recommend you strongly. I know him very well. He's very affluent. As a result of my representation, acting in good faith, you began investing money with him to do business in trust. But मालूम हुआ कि आपको you suffered losses. So my representation proved to be wrong. They are not honest representation. So they were fraudulent representation. So this is coming within the meaning of section 415 and 420 of the Indian Penal Code. 415 and 420 deal with cheating cases, isn't it? I had the intention to trap you, make you invest money with Kumar. I falsely projected to you that he's a rich man, he'll invest money. And you also have money, joint venture karo aap. I am there like a guarantor. I vouch for you. So my representation you acted upon as a good friend, as a good well-wisher, as your teacher who know me very well. But you came to know the gentleman whose name I took right now. Actually, he doesn't have so much money. And he induced you through my representation and made you invest money, and your money is gone. So you have a right to file a case against me also joining me that you acted in fiduciary capacity. Sanjana, you acted in fiduciary capacity and parted with money. So law of trust में सीखेंगे आप. When you see Indian Trust Act में पढ़ेंगे आप. So you come to know what is a how you act in representative. You know specific relief act में भी पढ़े हैं आपने. Section 2 definition में what is a trust, what is a fiduciary capacity. So that is very well known to all of you. So for leading evidence of fiduciary capacity, then provisions of illustration F is invoked to show that here you suffered losses and you should be recompensated. You must be reimbursed. Huh? Agency relationship under the Indian Contract Act, section 101, 201, 202, 203, 204, 205. chapter है इसके अंदर. So agency was taken from the principal. The principal induced the agent, I will give you good margin in the business, you get business. So on account of the representation, he will give me good margin. I brought a lot of customers, but he never paid me anything. He cheated me. खाली वड़ा पाव खिला के भेज दिया मेरे को. So you suffered losses on the basis of the representation. So that is, this explanation will be helpful to you in this regard. Yeah. Yes. The fact that there was no previous quarrel between A and B, and A repeated the matter complained of as he heard, are relevant, showing that A did not intend to harm the reputation of B. So this is with regard to show the ill goodwill. I hold in high reputation. I never heard it. Whatever you heard it from the other people is wrong information. So there is an erroneous notion on your part that please dispel it. I do not have such intention. Yes. F ho gaya, sorry. Then yeah. The fact that at the time when A represented to C to be solvent was supposed to be a solvent by his neighbors, or was supposed by neighbors and by person dealing with him, is relevant, showing that A made representation in good faith. So I can, you may have suffered on account of my representation, and you filed a suit against me and Kumar that both of you have cheated me. Otherwise, I would not have said it here. I have a right to show that I have evidence to show that I had gone to his place and they are neighbors. He was in a sound condition, financial condition. Whatever I made, whatever business losses have taken place, very unfortunate. Business is a game of fluctuation. Nobody can take guarantee. There is uncertainty. Just because you did not make profit, you cannot blame the me and the other, the Mr. Kumar in the matter. So whatever recommendation I did it, I made the recommendation that he's a solvent person in a good faith. I have nothing to do. I am not a privity to contract. I do not receive any consideration. Only as a neighbor, as a good friend, as a professor, I know I recommended his name. When you ask me, recommend some good people who can invest. So that evidence can be shown in that regard. Yeah. G. A is sued by B for the price of work done by B. A is sued by B for the price of work done by B upon a house of which A is owned by the order of C the contractor. A's defense is that B's contract was with C. The fact that A paid C for work in question is relevant as proving that A did in good faith, making over to C the management of the work in question, so that A was in a position to contract with B and C's own account and not as an agent of C. So here this is the agency. You know that there is no direct proprietary of privity of contract between them here. The fact that A paid C for work in question is relevant. So A is a building owner, a property owner, a bungalow owner. A workman is C who was doing the work, and A did in good faith over C's management. C is the contractor. He is the person, a mediator between the workman and the owner of the property in question. C was in no position to contract with B on O's account and not an agent of B. He will say that here the amount he was paying directly to B, I was only guiding him, instructing him as to how to do the work. I am not a person who had engaged him. There is no privity between me. C will take up the plea with B. I do not have privity of contract. So the B has done the work of A has to pay him the money. No, I have not, since I am not involved in the matter, I am only guiding as a contractor on a position to contract B and C account, and I was not the agent. So I am not accountable if the workman has made. Similarly, if A, the owner, has not paid to B, I cannot be held responsible. So I am not acting in a fiduciary capacity for either A or C. समझे ना आप? He may be, I must have supplied material to him. I got the money. But B is doing for A, there's a direct property of contract. He told me to give me some worker. I given him. So he's paying him daily wages every day, 1,000 rupees per day, 500 rupees per day. I am not receiving any commission out of it. That money is not coming in my hand. So that C will take up the defense. Okay, that evidence in the to pray that there is no direct privity of contract. Yeah. Then A is accused of dishonest misappropriation of property which he had found. A is accused of the dishonest misappropriation of property which he had found, and the question is whether he had appropriated, believed to be in good faith, and in real owner could not be found. Now, what is misappropriation offense? Section 1403 खोलिए आप, मिलेगा आपको. 403 of the Indian Penal Code will tell you misappropriation. Yeah. 403, dishonest misappropriation of property. Whoever dishonestly misappropriates or converts to his own use any movable property shall be punishable with imprisonment for a term which may be extended to 2 years. Now यहाँ पे criminal misappropriation हो चुका है. Yes, that is the section I point out to you. Then see, misappropriation के लिए Indian Contract Act भी check करो आप. Section 100 relevant section is in the Indian Contract Act. Anybody remember it? Yes, 168 पढ़े आप. Misappropriation, finder of a good, he doesn't return the good to you. यहाँ पे dishonest misappropriation of property is a criminal offense. Now Indian Contract Act में section 168 पढ़िए. Right of a finder of a good may sue for specific reward offered. The finder of a good has no right to sue for the owner for compensation for trouble and expenses voluntarily incurred by him, or to preserve the goods, or to find out the owner. He may retain the good against the owner until he receives such compensation, and the owner has offered a specific reward for the return of the good loss, the finder may sue for such reward and may retain the good until received. So you found you found a diamond of a businessman somewhere on the road, any place. You are a founder of that particular good. So next day newspaper, you come to know the gentleman he had come to Bombay to visit and he is from Delhi. उसका एड्रेस और पता उसके अंदर होगा नहीं. नेक्स्ट डे इन द न्यूज़पेपर यू रीड कि आई लॉस्ट अ डायमंड which is valued about maybe 1 crore, 2 crore. Anyone who finds it, I shall give a reward of 10 lakh rupees. Underline the word. So, as a finder of a good, you have a right, you are bound and liable to return it goods to him. You have a right only to ask for the reward which he has announced, or at the most the cost of your traveling in case no. You have to return to him. And if you don't return, you are misappropriating. Section 403 लग जाएगा, dishonest misappropriation लग जाएगा. So in a case like this, illustration H लगेगा. A is accused of dishonestly misappropriating property which he had found, and the question is whether he appropriated it believed to be in good faith that he real owner could not find it. The fact that public notice of the loss of property has been given in the place where A was relevant, showing A did not in good faith believe that the real owner of the property could be found. The fact that A knew that he had reason to believe that the notice was given fraudulently by C, who heard of the loss properly, wished to set up a false claim to it, is relevant, showing that A knew the notice. He did not disprove a good faith. तो यहाँ पे 2-3 चीजें में ये एविडेंस लग जाएगा आपको. नंबर 1, the finder of the good under the provisions of 168 of the transfer of the contract act, he has a right to claim compensation for the trouble he has incurred, some reasonable compensation, or if award is specified, award he can retain, so long as you don't give me the reward you announce of 10 lakh rupees, I won't return it. He can withhold it. That is not appropriate. और पैसा देने के बाद भी रिवॉर्ड अनाउंस नहीं किया है, एंड यू आर अ फाउंडर ऑफ ए गुड, यू जस्ट कीप इट, कीप मम. पब्लिकेशन न्यूज़पेपर में आ गया, पढ़ने के बाद में बोलेंगे यू मे टेक दैट ईयर. सो वेदर इट वाज publication was genuine, not genuine, whether it is a booty or bounty for you, we do not know. So you may say that you retain it honestly without any ill will. You had no intention. You did not know about the publication. You are not a person who misappropriated. You are only a bona fide finder. So these are the various evidences which are allowed to lead with regard to show that here your intention, to show the goodwill or ill will, or showing the existence of your feeling under the provisions of section 14 of the Evidence Act, whether you suppressed it, whether you hidden it, why the reason for not handing it over to him, whether you had knowledge, no knowledge, ये सब चीजें, because the market के अंदर people must say that I have seen Mr. X, a student or some gentleman who was in the bike, he picked it up. पुलिस को बताया जाके, yes. So after thorough investigation, come to know that the articles are lying in your possession and you have a right to give explanation to that. Or whether you made genuine attempts to return it, you may show that here. Well, I tried to contact the gentleman. I had no address. I sent it neighbor. I went to the police station, lodge a complaint. Huh? I have certain article which I found. The police did not respond to me. So these are all statements and evidence which can be given under section 14 to either to prove yourself out of the clutches of misappropriation, or to incriminate the accused person that he deliberately misappropriated the property. Having found it, he is a trustee, having found it. Even if a third person, unknown person maybe, under the Trust Act, even a stranger becomes a trustee if he finds the property of third person. You know that under the English Trust Act, even under the Indian Trust Act, section 94, 96 में illustrations हैं. I think I will be able to cover it, not today. अभी time क्या है? Other lecture. We'll stop it here because I have other lecture. Okay, Kumar. I will
Yes,
take up
yes,
the
sir.
illustration and also give you the judgments of the Indian Trust Act example next lecture. Okay. Chalo, today no question session. Please question answer. Reserve it for tomorrow. Okay. Maybe tomorrow, Friday का दिन बताता हूँ. Is Saturday okay with you all, Kumar? If Friday cannot make it, Saturday का दिन okay रहेगा
Yes, sir.
आपको?
Yes, sir.
Yeah,
Totally, totally.
probably Friday lectures we can postpone it to Saturday. Please, we'll take the timing. Mostly same time में रखेंगे. Whatever time convenient you, we will discuss. I will discuss with you on Friday. Okay. Chalo, thank you. Sorry, I'm getting late. I'll hang now.
Yes,
Okay.
sir. Thank you
Bye.
so much, sir. Good night, sir.